Welcome to the law offices of Chris M. Ingram's Immigration Podcast. Today we're going to do a catch-up on the latest developments regarding President Trump's ongoing efforts to ban what is called birthright citizenship, which is protected under the 14th Amendment. Okay, let's get into it. Before we begin, we'd like to thank attorney Chris M. Ingram and his team for their diligent work in researching and preparing the legal research for this podcast to keep our listeners up to date on what's going on in U.S. immigration. If you truly appreciate these podcasts, it's essential that you like, follow, subscribe, and leave a comment on our various channels such as Spotify, YouTube, LinkedIn, and Facebook, as this significantly boosts the channel's reach. The best you can do for us is to leave a comment, as we'd love to hear from you. Please tell us what topics you'd like us to cover, and we'll see what we can do. Thank you so much for taking the time to do this. It means a great deal to us. Disclaimer: please do not consider any content on our channels as providing you with legal advice. If you would like a free consultation, please go to www.breakthroughusa.com. Finally, be sure to listen to the very end so you can see where we share how we think this issue is going to be decided. It's well worth a listen. Today, we're diving deep into a legal and constitutional battle that has significant implications for thousands of families and really the very fabric of American citizenship. We're looking at President Trump's executive order on birthright citizenship, what it aims to do, where it stands legally, and why it sparks such passionate debate.
Indeed, it's a critical moment. A real test, you could say, for understanding the delicate balance between executive authority and judicial oversight. And it really makes you appreciate the enduring value of full United States citizenship. Our legal team's research highlights how deeply intertwined this issue is with foundational principles of equality, the very definition of citizenship, and the protections individuals and families seek in a stable society. It's not just a legal question, it's a philosophical one about national identity, too.
Okay, let's unpack this then. As of today, August 28, 2025, where do things actually stand with President Trump's executive order on birthright citizenship? For listeners tuning in, what's the immediate practical reality of this order right now?
What's truly fascinating here, and actually quite a testament to the speed of the judicial system reacting, is the immediate impact. The executive order, which was issued on January 20, 2025, President Trump's very first day in office, mind you, is currently fully blocked nationwide. And this isn't just one isolated court wing, and we're talking about multiple lower court injunctions that have consistently prevented its implementation.
Multiple courts.
Okay, yes. These injunctions mean that despite the president's signature and the executive branch's clear intent, the order cannot be enforced. Not anywhere in the country. It exists on paper, sure, but in practice, its legal force is entirely suspended. It's created a kind of legal limbo for the policy itself.
So it's essentially on hold, completely unenforceable. That sounds like a significant hurdle for the administration's agenda right out of the gate. What does this immediate judicial pushback tell us about how the courts initially viewed the legality of the order?
Precisely. Our attorney's research indicates it's entirely unenforceable due to these relentless legal challenges that began almost immediately, like day one. The courts across various jurisdictions and, interestingly, with a remarkable degree of consistency, have upheld the 14th Amendment's protections as they've been traditionally understood for, well, over a century. This immediate and robust legal reaction creates, a climate of significant uncertainty for the administration's policy, while at the same time it probably offers a degree of reassurance for those who rely on birthright citizenship. It really highlights the deeply ingrained judicial commitment to establish constitutional interpretations, especially when an executive action seems to challenge such a foundational principle.
And the Supreme Court has had a say in this, right? I remember hearing about a major ruling earlier this year. Did they rule on the core issue of birthright citizenship itself, or was it something else entirely?
Yes, that's right. The Supreme Court of the United States did enter the fray. They heard arguments back on May 15, 2025, in a case called Trump v. Casa, Inc. However, their decision on June 27, 2025, was primarily focused on procedural aspects, not the core constitutionality of birthright citizenship itself.
Procedural.
How so?
Well, they decided to limit the power of lower court judges to issue those broad nationwide injunctions we were just talking about. Justice Neil Gorsuch, actually in a related context, noted that lower court judges may sometimes disagree with this court's decisions, but they are never free to defy them, really underscoring the hierarchy. So the ruling was about how injunctions are issued, not whether this specific executive order was constitutional.
Okay. That's a crucial distinction.
It really is. It directed lower courts to reconsider the scopes of their injunctions, suggesting they should perhaps be more targeted. So while it was a significant procedural development, the The substantive debate, the core question of whether the executive order is constitutional, that's still very much alive and winding its way through the appeals process in the lower courts.
That makes sense. So even with the Supreme Court weighing in on the scope of injunctions, the order remains blocked because the lower courts are finding other ways, like class actions perhaps, to maintain the challenges to its constitutionality. This whole situation really makes you appreciate the security of full U.S. citizenship, doesn't it? Just knowing that your status, or your child's status, isn't subject to these kinds of, political and legal back and forths in the long run.
Absolutely. That emotional and practical security tied to citizenship is undeniably a powerful motivator for many people. Our legal team notes that in this climate, where executive actions can create such significant uncertainty and, frankly, legal flux, many lawful permanent residents are actively considering naturalization, becoming full citizens.
Makes sense.
They're doing this not just for the unbreakable rights and protections it secures, like voting, but also for the amplified contributions it allows them to make to American society. Running for office, certain jobs, or simply living without that lingering doubt of policy shifts. Full citizenship offers a clear safeguard against the kind of legal limbo that these current debates create. It provides stability and peace of mind for individuals and their families. It's a powerful testament, really, to the value people place on being fully integrated into the fabric of the nation and how vital that security can feel when it's being debated like this.
That's a perfect segue. So if the legal battle is focused on blocking its implementation, we really need to understand what this executive order actually proposes. What did President Trump's executive order specifically direct federal agencies to do? And what's the underlying goal behind this highly controversial move?
The order is quite specific in its targeting. It directs federal agencies, think Homeland Security, Health and Human Services, to deny automatic U.S. citizenship to children born on American soil if, and this is the key part, if neither of their parents is a citizen or a lawful permanent resident.
Okay, so it's based entirely on the parent's status at the time of birth.
Exactly. It's not a blanket denial for all children born here, but rather a very particular interpretation based on parental status. The White House document outlined that this subsection would apply only to persons who are born within the United States after 30 days from the date of this order. So crucially, it wasn't meant to be retroactive. It was designed to change the status for future births under these specific parental circumstances, effectively creating a new category of residents.
And the goal behind that?
Well, the administration's goal, as articulated by the Department of Justice, is essentially to redefine who is subject to the jurisdiction of the United States under the 14th Amendment. By doing that, they aim to significantly narrow the scope of birthright citizenship, as it has been understood for over a century.
That's a very particular interpretation of the 14th Amendment. From what I understand, the traditional reading has been much broader, covering almost everyone born here. What's the specific legal argument the administration is making to justify this narrower interpretation?
It is indeed a significant departure from established precedent. The 14th Amendment famously states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. The administration, primarily through the Department of Justice, argues that the phrase subject to the jurisdiction thereof wasn't intended to grant birthright citizenship automatically to children of aliens who are present in the country temporarily or unlawfully.
How do they define subject to the jurisdiction, then?
Their interpretation hinges on the idea that subject to the jurisdiction implies full allegiance to the U.S. They contend that this full allegiance isn't held by those temporarily present, like tourists or students, or those unlawfully present. They often cite historical legal interpretations focusing on the intent to exclude children of foreign ministers or invading forces, arguing this principle should extend to this broader category of non-citizens. Eric MacArthur, who represented the administration in court, has been a prominent voice arguing for this nuanced and, yes, highly contested position. He suggests the current broad application was an unintended consequence that undermines national sovereignty.
That's a fascinating reinterpretation, focusing on full allegiance. But what makes this specific reading of subject to the jurisdiction thereof so contentious among constitutional scholars, especially those who argue against the administration's position?
Well, it's contentious precisely because opponents counter that subject to the jurisdiction simply means subject to U.S. law, which everyone physically present within the country's borders is. Regardless of their immigration status or their parent status, you break the law here, you face the consequences here.
Right, you're under U.S. laws.
Exactly. This reading reinforces the concept that all persons born here are full citizens, except for those very narrow, historically defined exceptions, like children of diplomats who have diplomatic immunity and are therefore not subject to the jurisdiction in the same way. The contention really lies in whether that phrase refers to allegiance, as the administration argues, or merely the legal authority of the U.S. government over a person within its borders, as it's been traditionally understood for over 100 years. This distinction between partial and full jurisdiction is truly at the heart of the legal battle.
So if this order were ever allowed to go into effect, which it currently isn't, what kind of administrative machinery would be required? You mentioned Homeland Security, HHS. Would hospitals suddenly become like immigration enforcement agents? What are the practical logistical challenges that would emerge?
Our researchers indicate it would involve a massive administrative undertaking if it were to proceed. Almost unprecedented, really. It would fundamentally change birth registration processes across the entire country. Federal agencies would need to establish entirely new, complex protocols for reviewing birth certificates and, crucially, verifying parental immigration status at the time of birth.
Wow, that sounds incredibly complex.
It is. Imagine the logistical and privacy challenges.
USCIS is cracking down on visa fraud, and even approved cases are being revoked.
Why was my visa denied? USCIS revoked my approval. At the law offices of Chris M. Ingram, we handle every detail with care. Every form, every fact, every time.
So join us for a free consultation. We do things the right way. Let us take care of you.
Hospitals, which are currently focused on healthcare, delivering babies safely, would suddenly be tasked with verifying the legal status of parents for thousands of births each year. This would affect facilities across the country, from huge urban centers like Los Angeles, which sees a high number of births, to non-citizen parents, to small rural hospitals in Texas along the border. It would create a complex, multi-layered system of verification. It could potentially delay birth certificate issuance, introduce new forms of bureaucracy, and create immense uncertainty for families at what should be, a joyous and private time. The sheer scale and intrusiveness of such an implementation are among the many reasons this order has sparked such intense debate and those relentless legal challenges we discussed.
This isn't just a legal skirmish, then. It sounds like a full-blown battle involving many different groups, each with deeply held beliefs about what American citizenship should mean. It really highlights those two competing narratives of American identity you mentioned earlier. Who are the main players on both sides, and what are their core arguments that illustrate this philosophical divide?
Definitely. On the administration side, you have the Department of Justice, with figures like Eric MacArthur, as we mentioned, arguing their interpretation in court. Their position is supported by a significant cohort of conservative commentators and policy think tanks. They tend to view this as a necessary step to protect national sovereignty and the integrity of American citizenship. They genuinely believe the current system is being exploited, perhaps, and that the 14th Amendment has been misread, leading to what they perceive as an unsustainable situation regarding immigration and national identity.
So their core argument is about control and original meaning.
Generally, yes. It often circles back to a strict, originalist reading of the Constitution, emphasizing the need for the nation to control its borders and define its citizenry more stringently.
Such as who, specifically from the conservative viewpoint? Can you give us some more direct insights into their arguments?
Absolutely. For instance, Heritage Foundation scholar Hans von Spakovsky argued back in a 2018 commentary, which became very relevant again during the 2025 debates, that, quote, "The president is correct when he says that the 14th Amendment to the Constitution does not extend universal birthright citizenship. A review of the history behind the amendment proves this. He, and others like him, contend that the original intent was primarily focused on granting citizenship to formerly enslaved people. They argue its application to children of non-citizens, especially those temporarily or unlawfully present, was an unintended and ultimately problematic consequence."
Yeah.
Similarly, White House Deputy Chief of Staff Stephen Miller stated in a June 27, 2025 Fox News interview, quote, "This executive order is about protecting the meaning and value of American citizenship. It's not about punishing anyone, it's about ensuring that citizenship is earned through legal processes. This perspective really emphasizes a more merit-based or controlled pathway to citizenship, rather than automatic inclusion based solely on geography. They frame it as essential for national security and the long-term health of the Republic.
And on the other side, who's challenging this order, and what are their fundamental objections to this reinterpretation of the 14th Amendment?
Opposing the order are powerful immigrant rights groups like CASA, Inc. That's an advocacy organization providing critical, legal, educational, and social services to immigrant communities across several states. They're joined by states like California and New Jersey, whose populations are heavily impacted by immigration, obviously, and also by class action plaintiffs representing the thousands of affected families directly. These groups argue the order is a direct and unconstitutional assault on established constitutional law, humanitarian principles, and the very ideals of equality and justice America claims to embody.
Do they see it as undermining core values?
Absolutely. They see it as an attempt to undermine the foundational promise of the 14th Amendment and, in essence, create a kind of second class of residents within the nation.
What's their core argument, then? It sounds like they're emphasizing a much broader, more inclusive reading of the 14th Amendment and its established history.
Precisely. California Representative Judy Chu, a Democrat, put it quite clearly in a January 21, 2025 press release. She stated, quote, "The 14th Amendment to the Constitution grants citizenship to any person born in the United States, regardless of the immigration status of their parents. President Trump's executive order repealing birthright citizenship is an unconstitutional attack on the very ideals of equality and justice that define our nation." End quote. She and her allies argue the amendment's language is clear, concise, and its historical application has been robust and consistent for over a century.
And legal experts agree.
Many do. Law professor Edilberto Roman emphasized this in a March 21, 2025 piece in the Yale Journal on Regulation. He wrote, "Trump is wrong on birthright citizenship, a son of immigrants' lesson on the Constitution." He argued, quote, "The text and history of the 14th Amendment make clear that birthright citizenship applies to all born on U.S. soil, subject only to narrow exceptions like children of diplomats." Professor Roman even draws on his personal heritage as the son of immigrants, highlighting how such policies erode the American promise of inclusion and opportunity. He underscores that pathways to full citizenship provide a safeguard against such erosions and enable greater participation in society. This side sees the executive order as a clear overreach that disregards established legal precedent and the fundamental values of American democracy.
It sounds like the debate is centered not just on historical intent versus a broader interpretation that has evolved over time, but also a fundamental conflict between legislative intent, as expressed in the amendment, and executive power. This really raises an important question. What happens when an executive order seems to bypass existing laws or constitutional interpretations?
That's exactly right. And it raises that crucial question about the separation of powers in the constitutional order. What was the original intent versus how has it been applied over time, particularly in light of subsequent court rulings and societal changes? The opponents argue that even if there was some perceived ambiguity back in 1868 during the amendment's drafting, the principle of broad birthright citizenship has been firmly established through over a century of consistent legal precedent, most notably by the Supreme Court itself.
And it might even conflict with existing statutes.
That's another critical layer. Harvard Law School professor Gerald Newman wrote in a May 19, 2025 op-ed, quote, "The executive order is not only unconstitutional under the 14th Amendment, but also violates the overlooked federal birthright citizenship statute. It represents an overreach that undermines congressional intent." So Newman suggests that beyond the constitutional challenge, the executive order might be attempting to bypass existing federal laws passed by Congress that actually codify birthright citizenship. This further entangles the legal and political dimensions of this contentious debate, challenging the role of Congress versus the president in defining citizenship.
Fascinating. So, to truly understand this current legal and philosophical battle, we really need to anchor ourselves in history. Why was the 14th Amendment written in the first place? And how does birthright citizenship factor into American law as we've known it for so long, particularly through key court decisions?
Birthright citizenship, or just solely, that's Latin for right of soil, became a cornerstone of U.S. law with the 14th Amendment's ratification in 1868. Its primary aim was absolutely clear and historically pivotal: to ensure citizenship for children of freed slaves. It was meant to definitively reverse the notorious Dred Scott decision of 1857, which had denied citizenship to African Americans and declared they could not be citizens.
A direct response to Dred Scott.
Exactly. The framers of the 14th Amendment wanted to unequivocally establish that anyone born on U.S. soil, regardless of their parents' previous status or race, was a citizen. This was designed to prevent the creation of a stateless underclass within the nation's borders and to guarantee a uniform definition of citizenship. It was truly a revolutionary act, fundamental to the post-Civil War Reconstruction era.
That initial crucial aim is undeniable, linked directly to the legacy of slavery. But it extends beyond that, right? It wasn't just for children of freed slaves in its application. That's how it's been interpreted and upheld for generations, hasn't it?
Yes, it absolutely extends beyond that, and this is where a critical precedent comes into play. The 1898 Supreme Court decision and the United States v. Wong Kim Ark is truly crucial here. This landmark ruling cemented the broad interpretation of the 14th Amendment's citizenship clause. The case involved a child, Wong Kim Ark, born in San Francisco to Chinese immigrants. His parents were not eligible for naturalization themselves due to discriminatory laws at the time, Chinese Exclusion Acts.
Right, so a challenging case for the time.
Very much so. But despite his parents' non-citizen status, the Supreme Court affirmed Wong Kim Ark's birthright citizenship. This decision established that nearly all persons born within the U.S. are citizens, irrespective of their parents' immigration status, unless they fall into those very narrow, historically recognized exceptions. We mentioned children of foreign diplomats or invading forces. This decision has stood as the bedrock of birthright citizenship for over 125 years. And this precedent is what Chief United States Circuit Judge David Barron referred to during arguments in the First Circuit on August 1, 2025. He said directly to the government's lawyer, quote, "We have an opinion by the Supreme Court that we aren't free to disregard."
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way.
Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
Wow. That's a powerful statement from a judge.
It is. It emphasizes the profound weight and binding nature of this precedent on all lower courts.
President Trump, however, has voiced a different view on the amendment's original intent, suggesting a much narrower historical scope than the one established by Wong Kim Ark. How does his interpretation clash with this long-standing precedent?
He has stated, for example, on June 27, 2025, after that Supreme Court procedural ruling, that the amendment was, quote, meant for babies of slaves. This reflects a broader agenda in his second term to shift toward stricter interpretations of citizenship. It's often framed around concerns of national security and the perceived strain on economic resources attributed to undocumented immigration. He views the current broad interpretation of the 14th Amendment, largely shaped by Wong Kim Ark, as an overly generous expansion beyond the amendment's original specific purpose.
So a direct challenge to Wong Kim Ark's interpretation.
Yes, this stance directly challenges over a century of established legal precedent and seeks to fundamentally reevaluate the meaning of subject to the jurisdiction within the amendment. The aim is to restrict it only to those whose parents owe full and complete allegiance to the U.S. government. It's a direct confrontation with the established legal framework and, arguably, the traditional understanding of American identity as a nation built by immigrants.
Our legal team, attorney Chris Ingram, has also weighed in on the constitutional integrity of this, specifically on how changes should happen. What's his impartial analysis on how an amendment, particularly one so foundational, should or shouldn't be changed?
Indeed. Attorney Chris Ingram provided an impartial analysis, stating, "The integrity of the 14th Amendment must be upheld, as constitutional amendments should only be changed by the express will of the American people following the proper protocol." Unquote. And he specified that protocol proposal by a 2/3 vote in both the House of Representatives and the Senate, followed by ratification by 3/4 of the state legislatures.
The formal amendment process.
Exactly. He continued, "Any attempt to alter such foundational rights through executive action alone undermines a democratic process and the rule of law. This perspective underscores the constitutional architecture, the checks and balances, and the high bar deliberately set for altering fundamental rights. It highlights that executive orders, by their very nature, aren't designed, nor do they possess the authority to override or reinterpret the Constitution in such a significant and sweeping manner. This strict adherence to constitutional procedure is a core argument against the executive order's legitimacy from a process standpoint.
Here's where it gets really interesting, perhaps even a bit dizzying for those of us following the news. This executive order has been in and out of court since day one, creating a whirlwind of legal challenges. Can you walk us through the major legal developments that have unfolded, maybe chronologically, and explain the significance of each step in this legal gauntlet?
You're right. It has been a whirlwind. Legal battles ignited almost immediately after the order's issuance on January 20, 2025. Initial temporary blocks came swiftly back in January and February 2025 from district courts in places like New Hampshire, Maryland, and others. These early injunctions were crucial because they prevented the order from ever taking effect, even for a single day. It showed a quick, strong, and widespread judicial reaction.
So the initial response was strong. Then things escalated pretty quickly, especially with class action lawsuits and the appellate courts getting involved. This sounds like a strategic legal pivot after the initial blocks.
Yes, things definitely escalated. By July 10, 2025, a federal judge in a significant class action lawsuit granted a preliminary nationwide injunction. And crucially, that judge certified a class of affected children. This class action approach effectively gave the injunction broad, nationwide reach, protecting thousands of potential plaintiffs simultaneously. It was a strategic move, especially anticipating potential challenges to broad injunctions.
Ah, clever.
Then a major blow to the administration came on July 24, 2025. The United States Court of Appeals for the Ninth Circuit, that's a powerful federal appellate court covering many Western states, ruled 2-1 that the order is unconstitutional. This ruling not only upheld a previous block by District Judge John C. Coffiner in Seattle, but added significant weight and appellate precedent to the legal opposition. The Ninth Circuit's decision was a powerful affirmation of the established interpretation of the 14th Amendment. They basically said the government hadn't presented a compelling argument to overturn over a century of law.
Okay, Ninth Circuit says unconstitutional. We mentioned the Supreme Court earlier, though. How did they specifically enter this fray, and what was the precise impact of their decision given these ongoing blocks? It seems counterintuitive if they limited injunctions, yet the order remained blocked.
Right, it can seem confusing. The Supreme Court entered the fray on those procedural grounds we discussed. They heard arguments May 15th in Trump v. Casa, Inc. Then on June 27th, they issued that ruling limiting lower court judges' power to issue broad, nationwide injunctions. Remember Justice Gorsuch's point about not defying the high court.
Got it. Focus on the how, not the what.
Exactly. The ruling was significant for judicial procedure, reflecting concerns about the scope of injunctive relief and maybe a desire for more restrained judicial action. It was a signal to district judges. Don't issue blanket nationwide injunctions from a single court. Make them more targeted.
But this didn't let the order take effect, right? That's what's so puzzling. How did the legal community adapt to this Supreme Court guidance while still keeping the order blocked?
Crucially, no, it did not let the order take effect. The ruling, again, didn't address the order's merits or constitutionality directly, so the core legal challenge remained totally valid. Instead, it directed lower courts to reconsider the scopes of their injunctions. But the legal community is incredibly adaptive. What we then saw was a strategic pivot. Instead of one judge issuing a broad injunction covering everyone, lower courts adapted by using class action certifications for nationwide relief.
So protecting a class achieves the same result.
Effectively, yes. A judge could protect an entire class of affected individuals, say, all children born after a certain date to non-citizen, non-LPR parents across the country. This achieved a similar nationwide block, but through a different legal avenue that seemed more aligned with the Supreme Court's procedural guidance. For instance, on August 8, 2025, Judge Deborah Boardman in Maryland extended a nationwide halt in a suit brought by undocumented mothers, specifically calling the order almost certainly unconstitutional. This demonstrated the resilience and, frankly, creativity of the lower courts in finding ways to prevent the order from being implemented. And you had state leaders, too. Illinois Governor J.B. Pritzker, a Democrat, declared back on January 21, 2025, "We will not follow this unconstitutional order. We stand ready to challenge it in court," signaling a unified front.
So the administration is still appealing these decisions, trying relentlessly to get the order implemented. This sounds like a continuous legal battle, a sort of legal cat-and-mouse game between the executive and judicial branches. What's the absolute latest in this ongoing saga?
It is indeed a continuous legal battle, a real testament to the high stakes involved for both sides. Another significant block came just recently, on August 12, 2025, when a fourth federal judge issued a nationwide injunction citing constitutional violations and building on that Ninth Circuit precedent. This further solidified the legal opposition. The Trump administration has predictably appealed multiple of these decisions, including going directly to the Supreme Court again on August 7, 2025, asking for emergency stays to lift the blocks.
And did they get them?
No. No emergency stays have been granted, meaning the order remains completely blocked nationwide as we speak. Also, oral arguments held in the First Circuit Court of Appeals on August 1, 2025, reportedly showed judges leaning heavily toward upholding the block in their region too. No ruling has been issued there yet as of August 28th, but the indications are the judicial system continues to hold the line. Professor Gerald Neumann summed up this ongoing tension well in that May op-ed, noting the order wasn't just unconstitutional but also violated statute and represented an executive overreach. These developments illustrate the ongoing tension: rapid executive actions versus the deliberate, often slow pace of judicial review, with lower courts repeatedly invoking history, precedent, and statute to maintain the status quo while the administration pushes hard through the appellate system. It's a powerful illustration of checks and balances at play.
This abstract legal debate, with all its constitutional arguments and court dates, has very real, tangible consequences for people. It affects families, their stability, their futures. Beyond the legal principles, do we have any examples from our team's research that bring this home for us, illustrating the human toll of this uncertainty and perhaps, conversely, the profound positive impact of citizenship when it is secure?
Absolutely. Our research often includes narratives that underscore this profound human impact, painting a vivid picture of the stakes involved. Consider, for example, a story about Margit. She's a highly skilled German software engineer who came to the U.S. on an H-1B visa, contributing her expertise to a Silicon Valley firm for 3 years. She and her husband Hans, an automotive engineer also here on an H-1B visa, recently discovered they're expecting their first child in about 6 months.
Okay, so legally they're here properly, skilled workers.
Exactly.
Yeah.
And even though no laws have actually changed for them, their legal status is secure, and their child, under current blocked law, would still be recognized as a citizen. The ongoing news about the executive order and its relentless legal challenges has left them deeply unsettled. Margaret describes sleepless nights, constantly worrying about the potential future implications for their family's stability and their child's future status in a country they've grown to call home. It isn't about immediate deportation for them. It's about that gnawing uncertainty for their child's long-term belonging and their ability to plan their lives here without this cloud of legal ambiguity hanging over them.
You finally got your family together on a H-1B. Your American dream begins. Your employer files for your EB-2 green card, but the wait is over 11 years. As the years go by, frustration grows, and now the company is talking about layoffs. This could be the end of your American dream. You search for help, but luckily, you land on BreakthroughUSA.com. They listen, reassured you, and built your EB-1 case with precision. Then one day, a notification buzzes, EB-1 approved. With your EB-1 green card, your entire family can breathe.
I have got my visa. I got my visa.
That's why the law offices of Chris M. Ingram is trusted. Your future shouldn't wait. Let's talk EB-1.
What are the next steps?
Need help with your visa? Book your free consultation now at www.breakthroughUSA.com and let us take care of you.
That's a powerful illustration of the uncertainty. Even for people on secure legal visas, the very discussion of changing birthright citizenship can create significant anxiety. It's about more than just legal status. It's about a sense of belonging, isn't it? And the future they envision for their children. Are there other stories that reflect different facets of this human impact?
Exactly. It hits at that fundamental sense of security. And such personal accounts reveal the widespread human toll, echoing broader narratives from countless immigrant families who contribute daily to our communities economically, socially, culturally, while constantly navigating this legal and political limbo. Beyond Margit and Hans, think about someone like Maria, an undocumented mother from El Salvador who's been living and working here for over a decade. She has a U.S.-born child attending elementary school. For her, the threat of this executive order isn't just an abstract legal limbo. It's the constant visceral fear that her child, born here, might somehow be stripped of the only citizenship they've ever known. It could create a permanent underclass right here in America. This anxiety permeates every single decision she makes, where they live, how she engages with schools, health care. It potentially pushes families further into the shadows, away from vital services. The prospect of having a child whose status is uncertain creates immense psychological stress and compounds existing vulnerabilities.
It truly highlights the profound stakes for families already here. But on the flip side, you mention inspiring stories that showcase the positive impact of full U.S. citizenship. What do those stories tell us about what's gained when citizenship is secure?
Right. On the flip side, our team also collects these inspiring stories that showcase the profound positive impact of full U.S. citizenship. They highlight what is truly at stake and what we stand to lose or preserve. For example, we have the story of a Haitian client who naturalized in 2024 after years as a green card holder. She built a life from the ground up through sheer determination. She now runs a highly successful small business in her community, employing locals, paying taxes, contributing significantly to the local economy, really fostering local growth.
That's fantastic.
It is. Or consider the Indian-American family who naturalized back in the 1980s, embracing their new nation wholeheartedly. One of their children, a U.S. citizen by birth, grew up to become a diplomat, representing the United States on the global stage. Imagine that embodying the very ideals of American opportunity and service. These stories powerfully demonstrate how citizenship unlocks pathways to contribute, to innovate, to serve, and to give back to American society in myriad ways. They are a testament to the idea that inclusion strengthens the nation, providing a stable foundation for individuals to reach their full potential and enriching the country in turn.
Beyond the individual and immediate families, what are the larger implications of this debate, both if the order were to somehow pass and reshape citizenship, or if it continues to be blocked by the courts, preserving the status quo? What are the economic, social, and political repercussions we should be considering here?
The broader implications are truly far-reaching. They touch almost every facet of American society. If the blocks continue to hold, well, they preserve birthright citizenship for U.S.-born children. That offers stability to potentially millions of immigrant families, allowing them to plan, invest, and raise their children without that fundamental uncertainty about legal status. This stability is crucial for social cohesion and long-term economic planning. However, should the Supreme Court eventually reverse these injunctions and allow the executive order to take effect, the impact would be profoundly disruptive.
How so?
It could disrupt millions of lives. It could potentially lead to a system of tiered citizenship, where some U.S.-born children have fewer rights or a less secure status than others. This would create immense administrative chaos in birth registrations, like we discussed, forcing families to navigate incredibly complex legal hurdles to determine their children's status. It could potentially create a shadow population without clear rights or belonging, and deeply fracture social trust.
And what about the economy? How does this debate and the potential outcome connect to the economic health and growth of the country, especially with all the data our team has compiled?
Well, if we connect this to the bigger picture, the debate often critically overlooks the profound positive contributions of immigrants to the American economy. Our team's studies from 2025 consistently show that immigrants aren't just passive participants. They are significant active drivers of overall economic growth. They achieve this by expanding the labor force, which is absolutely crucial for an aging population facing declining birth rates, and by increasing consumer spending. Plus, foreign-born individuals start businesses at significantly higher rates than native-born Americans. They're nearly twice as likely to become entrepreneurs, fostering innovation, creating jobs, and invigorating local economies. This entrepreneurial spirit is a vital engine for economic dynamism.
Are there any specific numbers to back that up? These broad statements can sometimes feel abstract without concrete data to illustrate the magnitude of their contribution.
Yes, absolutely. The numbers our researchers found are compelling and often surprising. Immigrants inject trillions of dollars into housing wealth and pay billions in taxes annually. For instance, undocumented immigrants alone, despite their legal status, contribute an estimated $25.7 billion in Social Security taxes each year. That supports programs like Medicare and unemployment insurance, which benefit all Americans.
$25 billion just from undocumented workers.
That's the estimate, yes. Beyond that, refugees and asylees, often perceived in public discourse as primarily a cost, actually generate an impressive $123.8 billion in net fiscal benefits over just 15 years. That demonstrates a rapid return on initial investment. And looking at the big picture, immigrants as a whole contribute a substantial 18% of the nation's total economic output. That equates to a staggering $2.1 trillion in 2024 dollars. These figures highlight a critical economic engine that is often underestimated or entirely ignored in public discourse, underscoring their vital role in sustaining and growing the U.S. economy.
That's incredibly significant. So beyond the sheer numbers, what other impacts do immigrants have that might be overlooked in this debate? And what are the potential long-term consequences if birthright citizenship were to be curtailed?
Well, beyond the financial contributions, immigrants are vital drivers of innovation across various sectors. Think leading groundbreaking research in tech and medicine, developing new cultural products and services. They fill crucial labor shortages in essential sectors like healthcare, agriculture, construction areas where native-born workers are often scarce or perhaps less willing to take on certain jobs. This ensures the continuous functioning of critical industries. Furthermore, they enrich cultural diversity, bringing new perspectives, traditions, and ideas that foster a more resilient, dynamic, and vibrant society.
And the downsides if citizenship is denied.
Conversely, denying citizenship to U.S.-born children could have severe negative consequences down the line. It could significantly shrink the future workforce. That would place immense strain on Social Security and Medicare programs, especially with an aging population. And it would likely exacerbate existing labor shortages in critical areas like elder care and food production. It's a demographic challenge that policy really needs to address proactively, not make worse.
What about the international and political fallout? This kind of policy doesn't just happen in a domestic vacuum, right? It has global implications.
That's absolutely right. Policymakers face significant international backlash potential. Allies like Mexico have already expressed strong protests over the discriminatory effects this order could have on their citizens and those with familial ties to the U.S. Such actions could strain diplomatic ties, complicate trade relations, and potentially undermine America's standing as a beacon of democracy and human rights. That has broader geopolitical consequences. Domestically, politically, this issue just fuels congressional stalemate. Republicans, like Representative Chip Roy, introduced bills on June 27, 2025, aiming to, quote, end birthright citizenship once and for all, indicating a sustained legislative effort alongside the executive action.
So it's being fought on multiple fronts.
Exactly. And communities, especially in border states, might see profound demographic shifts affecting schools, healthcare infrastructure, local economies. Estimates suggest that something like 4.7 million U.S.-born children of undocumented parents could be directly impacted if this were ever enacted, exacerbating social tensions and community integration challenges. And this isn't just a legal question. It touches on global migration trends driven by climate change, economic disparities, geopolitical instability, rising displacement from regions like Central America and Africa, pressures U.S. borders, and prompts these kinds of reevaluations of longstanding policies, creating a really complex web of interconnected issues.
So as we survey this incredibly complex landscape, legal battles, historical context, profound societal implications, what does this all mean for the future? Given all the competing arguments and the deep divisions, how might this issue ultimately be decided? What's the most likely path forward from here?
Well, the immediate future, as is often the case with such profound constitutional questions, really involve the Supreme Court. They are currently on summer recess until October 7, 2025. We could realistically see them decide on certiorari, that is, whether they will agree to hear the case on its merits perhaps by late 2025. If they do grant certiorari, oral arguments could potentially be scheduled for early 2026. A definitive decision might then come by June 2026, which is typically when the court wraps up its term. This timeline really highlights the deliberate, sometimes frustratingly slow pace of judicial review, especially compared to the rapid executive actions we've seen. It reminds us that fundamental constitutional questions aren't resolved quickly or superficially, but through a rigorous, methodical process.
And the different philosophical approaches to interpreting the Constitution will surely play a significant, perhaps even decisive role in how the Supreme Court might ultimately view this. We have originalists versus those who might favor a more evolving, living interpretation of the Constitution. How do these differing philosophies shape the likely arguments and potential outcomes?
Absolutely. Those philosophical underpinnings are central to this entire debate and will undoubtedly guide the justices' deliberations. From a conservative academic viewpoint, you have arguments like the one Michael Anton, a former Trump national security official, made in a December 2024 piece. He argued, quote, birthright citizenship has been fundamentally misunderstood. The 14th Amendment was never intended to grant automatic citizenship to children of illegal immigrants. Reinterpreting it aligns with original intent and protects national sovereignty. This perspective champions originalism, the judicial philosophy that the Constitution should be interpreted as the framers originally intended, without incorporating later societal changes or judicial expansions. It strongly emphasizes national sovereignty and a nation's right to control its borders and define its citizenry strictly.
While others, of course, take a very different stance, emphasizing the historical impact and the promise of America as a land of opportunity and inclusion. How do these counter-arguments reflect a different philosophical lens?
Indeed. On the other side, you have groups like the Chinese American Advocacy Group. They stated on January 2010, 2025, quote, "Our immigrant parents left behind family and familiar rituals to seek a better future for us. Being born in the U.S. gave us access to opportunities that we cherish, and we must protect this right for future generations." This perspective emphasizes the historical inclusivity of the amendment, the lived experiences of immigrant families, and the enduring idea of America as a land of opportunity, a melting pot. This view often aligns more with the living Constitution philosophy, where constitutional principles are seen as evolving to address contemporary challenges and uphold broader concepts of equality and justice. These contrasting views underscore a deep ideological rift, emphasizing sovereignty in a strict originalist reading versus highlighting equality, historical inclusivity, and the evolving nature of American identity and the promise it holds. The ultimate resolution will hinge on how the Supreme Court weighs these foundational principles over a century of precedent like Wong Kim Ark and these differing interpretations of constitutional intent.
So the path ahead is clearly fraught with legal and political challenges, with truly significant implications for what it means to be an American citizen and for countless families across the country. It's a debate that touches the very core of our national identity and challenges us to define our values moving forward.
It really does. And this raises an important overarching question for all of us, for you listening. In a country grappling with its foundational principles and its place in an increasingly globalized and interconnected world, how do we effectively balance the desire for national sovereignty and a stricter interpretation of our laws with the promise of equality, inclusion, and opportunity that has long defined the American experience and attracted people from every corner of the globe? The ultimate resolution of this debate will not only redefine the practicalities of citizenship, but will also profoundly shape the very identity of our nation for generations to come. It will influence our demographics, our economy, our social fabric, and our standing on the international stage. It's a question with enormous consequences.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Again, if you truly appreciate these podcasts, it's essential that you like, follow, subscribe, and leave a comment, as this greatly boosts the channel's reach. Thank you so much for taking the time to do this. It means a great deal to us. Also, follow us on YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for preparing this legal research for our presentation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughusa.com and schedule an appointment. We'd love to hear from you and help you if we can. Bye for now.